Good afternoon, everyone. This is Jim Houlihan. I'm a member of Bond, Schoeneck King. As most of you know, Bond is a full-service law firm that provides services at 9 different offices across the country, 7 of them in New York. I'm here with my colleague Bethany Centrone. Bethany's been in practice for many years, some in private practice, but before joining Bond, she actually was Chief of Human Capital Initiatives at the Rochester City School District. So I'm happy to present with her today. She has a very upfront and personal view of some of the issues that we're going to be talking about in today's webinar. Without further ado, we'll move on. We do want to let you know that this is the first of 5 public sector webinars that we plan to do over the next several months. I'm sure that we've met several of you, many of you, at our annual workplace seminars, but we noticed in recent years that attendance from our public sector clients had been declining, and in conversation with some of our public sector clients, we realized that with the demands on your time and the financial constraints that many of you are dealing with, that many of you did not have the time nor the budget to attend our annual seminar. So Beth and I began to think about how we might continue to provide education and credits to our public sector clients. So this webinar was born out of that discussion. So we're very happy to have you here with us today. You can see on the screen are the topics that we plan to cover in the next several webinars. Not all of them are labor and employment related, but we hope that you'll return and enjoy those webinars as well. Today, the focus of the webinar is managing employees from evaluation to investigation to corrective action. Obviously, as all of you who are involved in the public sector know, this is a topic that cannot possibly be covered in 45 minutes of webinar. What Bethany and I hope is that over the next 45 minutes we can provide you with a handy checklist, if you will, whenever you find yourself in a situation where you're engaged in the management of employee performance or employee discipline. We hope that the outline will serve as a checklist to make sure that you don't miss anything, that you don't overlook some of the legal obligations that public employers have in these situations. And toward that end, right now, obviously, you can see the slides in our presentation, but after the program, we will be sending you the presentation in presenter mode so that all the comments and case references that we're going to have access to will also be part of a presenter mode outline that you'll have for future reference. We hope that you use it as a checklist, as I said, for going forward. We also hope that you will use it to remember our phone numbers and call us if and when you have concerns that are other than routine in this arena. So moving on to the content of the presentation, just for order purposes, I'm going to do the introductory section concerning performance evaluations. Bethany's going to then pick up and do investigations and corrective action, and then I'm going to finish the presentation talking about related issues and concerns whenever you're in a employee discipline situation.
And please, if you have any questions during the webinar, type those in, and we'll make sure to try to get to those before the end of the presentation.
Yes, please do. One of the reasons we decided to do this jointly is so that you wouldn't have to listen to us talk on, continually for 45 minutes. So please, those questions will help break the presentation up, and will also serve as further points of education for all those who are participating. So moving on to performance management, one of the things that I've seen in my experience with public sector employers, and my experience has been primarily with municipal employers, not necessarily school districts, but at least in my experience, one of the things that employers tend to shy away from is any formalized performance appraisal program. I saw that especially in a lot of the municipalities that I worked with. I think it was born out of a sense that, well, why should I evaluate performance? I'm still stuck with Section 75 or an arbitration if there's any problems. Alternatively, I think a lot of municipal employers didn't want to go through having to negotiate procedures for dealing with performance appraisals. And I worked with a small village maybe a decade ago, and the administrator for that village was pressing me that in collective bargaining he wanted to negotiate a performance appraisal system. And the consequences of a bad appraisal were not substantial. Essentially, the best we could negotiate was you couldn't do any worse than normal, but you might do better if you got a positive review. And I asked this administrator, why are we doing this if really the financial implications are not that great? And he explained that he thought it was very important that at least in his case, 2 times a year, he sat down with every employee and talked to them about their performance, had an opportunity to remind them what his expectations and the village's expectations were at the midterm meeting, and at the end of the year had an opportunity to praise the individual for positive things that happened and talk about areas where their performance could improve. He also said, Jim, it also is a reminder to them at least twice a year that we have expectations, that we expect them to come to work ready, willing, and able to serve our client, the municipality, and it worked pretty well for many, many years, and I believe is still being used. So the first thing I would say is if you haven't ventured down that path, even if you have collective bargaining relationships with your non-managerial employees, I think it's something that you should seriously consider. Performance management, as I said, can hopefully motivate the best, manage the rest, and help you make fair and good decisions about a variety of the personnel issues that come up during the course of managing complex organizations. So obviously everything needs to be personalized. What works for a small village isn't going to work for a large school district. And on that topic, Bethany and I don't intend to cover some of the, I guess, cumbersome and in some ways obtuse APPR requirements in this presentation.
Right. In our note slides that we'll be sending you later, we have links to webinars and presentations and information that Bond has done previously on APPR. For those of you that aren't school districts, that's the annual professional performance review process for classroom teachers and principals. We will touch upon things that are important to all evaluations and all performance management, but this specifically won't deal with APPR.
Great. If you do have questions, though, in that arena, I encourage you to include them in your response, and I will quickly forward them to Bethany for her response. So let's talk generically about performance management, employee evaluations, you know, for non-instructional personnel. You know, this is a very personalized approach. I think if you went out and Googled performance management or employee evaluations, you probably would get hundreds of different forms, different ideas, that type of thing. I encourage you to do that and begin to accumulate what appears to work or might work for your particular circumstance. The village that I mentioned, we ended up with a one-page form. As much as the administrator wanted to review performance, he didn't want to spend hours writing performance reviews. So the tool that we developed had certain standards that were expected of every employee, had an opportunity to rate that individual, an opportunity for the individual to comment on his or her performance, and an opportunity for, you know, small opportunity for personalized comments and observations. So in terms of driving an effective performance management system, I think one of the key things that you need to do is develop a system that you can honestly live with. You might develop a very elaborate and very effective and good performance management system, but if it takes so long for you to develop the evaluations or your subordinates to develop the evaluations that you dread it, you know, if it's something that you only reserve to do in the late hours or on the weekends because you never can seem to fit it into your regular schedule, then I'm going to suggest to you that that evaluation tool is actually holding you back instead of assisting you. So in terms of developing a process or a tool, obviously one of the aspects is to develop goals, set realistic goals based on the parameters for that individual's position. Make sure that you don't miss an opportunity to let them know what they're doing well and to show your appreciation. Give them an opportunity to comment and give them some idea about where there might be opportunities for them in the future and how they might fit in the evolving organization that you're leading. And finally, I think one of the things you have to be prepared to do as you develop or revise your system is to deal with underperforming employees. Not only for that employee's sake, but a lot of times you're not the only one that understands how poor a particular employee's performance is, because inevitably that poor performer affects their coworkers, and that causes stress not only for you but for their coworkers as well. So I think as you're developing a tool, make sure that you're committed to dealing with underperforming employees. I don't know, Bethany, have you had that experience where a client comes to you and they really have performance problems with a particular employee, and yet when you look at the history of performance reviews, the person's gotten 3 or 4 bad reviews, has disciplinary issues, and yet they're still employed?
Well, I think that I have seen that. I think, you know, what I see, what I would see more frequently is that employee, looking at that employee's performance reviews and seeing that they're all in the satisfactory range, or they're actually not that, they don't look that bad on paper. And that's the other, you know, the other issue with performance management is making sure that you're conducting accurate evaluations of your staff, because an evaluation that does not accurately reflect what your employee's performance is worse than one that is completed but inaccurate if you're ever in a situation where you have to defend a termination or an employment action.
I agree completely with that observation. So we talked a little bit about a good management tool. There are a lot of great ideas out on Google. There's a lot of great resources that you can access. But I would encourage you, as I said, to develop a personalized tool that fits for your situation and might have to be modified for different bargaining units, different levels of performance or levels of responsibility. But again, at the end of the day, develop a tool that you're actually going to use. It's better to have a tool that you're going to use and faithfully adhere to a performance review process than to have a great tool that sits on your desktop and you groan every time you think about opening it. So evaluations really are not discipline. They necessarily shouldn't be discipline because Bethany's going to talk about what discipline involves and how New York law provides a variety of protections for employees who are being disciplined. But performance appraisals can be a very solid groundwork that will provide the foundation to lead to discipline. For example, the evaluations can satisfy what is an essential requirement of any sustainable discipline, and that is notice to the employees of what is expected. So in addition to job descriptions and one-on-one coaching and training, the evaluations can be used as evidence that the employee knew what behaviors were expected of them. So it's another reason to consider doing regular performance reviews, even if they're not part of your current process. Of course, some of you may not be able to do all the performance reviews of the people that respond to you, so or report to you. So you will need to develop a tool to keep track of the evaluations that your subordinates need to do, and also provide training for them about what an effective and usable performance evaluation should contain, as well as identifying those problematic comments and other items that should not be part of an evaluation. For example, anything that would tend to show a discriminatory motive, or consider matters that really don't go directly to a person's performance. Obviously, there is a written, typically, component to evaluations, but there's also the benefit of that face-to-face communication. It's unfortunate, but a lot of times the drafting of the performance evaluations and the preparation for the face-to-face meeting often slide to the bottom of our to-do list. So it's very important that you be prepared for the face-to-face evaluation. We suggest that if you're not prepared, or you really are not in a situation to give your 100% attention, that it's better to reschedule, obviously in a timely fashion, than to go ahead with an evaluation which does not have optimal conditions. I think there's probably nothing worse than to have a high-performing employee go to a performance evaluation at which they're underwhelmed. In other words, it's as important to be prepared for employees that don't have any problems, so that you can reinforce and encourage and thank them, as it is to be prepared for that employee who needs some, counseling and redirection. Obviously, as Bethany pointed out, be fair, but also be pointed if there are problems that that need to be addressed. None of us likes to have those difficult conversations, but I think if you've done your homework putting together the written performance review, typically that will include examples of the problematic behavior, and oftentimes that can form the basis for a positive discussion in the face-to-face meeting. One of the things that this particular village administrator developed to help him do his annual evaluations, he developed a mini review, quick review form that he could use to counsel employees if he found them doing an exceptional job or if he found them perhaps not living up to expectations. It was a simple half-page form, took a few seconds to fill out, and was a multi-page form. He gave the employee a copy of the counseling, kept a copy in his file, and then put one in their performance file, or personnel file, which he reviewed prior to actually preparing the annual review. Now Bethany may tell you that it's a potential problem to put those things in the personnel file, but I'll let her address that when she gets to that stage.
Now, there's one thing on that slide that I want to point out, especially in a public employment situation where a lot of our employees have a due process rights. It's difficult to terminate public employees frequently, so some of them aren't always the best workers. But I think that what we want to make sure that we do when we evaluate is to compare to what our expectations of standards are, not compare them to whatever coworkers might not be meeting the standards. So being the best of the worst in an organization doesn't mean that you're exceeding expectations. It just means that you're exceeding what other people might be doing. You want to appreciate those people that are performing better than their coworkers, but you do want to make sure that you're considering what the expectations are as opposed to what the other employees might be doing if you really want to raise your whole organization up to a higher standard of performance.
Yeah, that's an excellent point, Bethany. Mm-hmm. One thing that Bethany and I talked about as we were putting this presentation together is the need to look back historically at someone's performance. Typically that might involve looking at their personnel file, but I think there's also a cautionary note that needs to be raised there. You want to focus on the most recent behavior. If there's been progress, you need to compare that to prior evaluations so you can comment on it. If there's been a continued deterioration, you need to look back so you can comment on that deterioration. But one of the problems of perhaps looking at someone's entire personnel file is that you may see things that are properly in the file that would indicate the person's age. Hopefully there's nothing in the personnel file that will indicate any medical issues or disability. If there is, it shouldn't be. All that medical information should be kept separately. But I think that if in a larger organization, when it comes time to doing evaluations, I would make sure that you limit the documents that an intermediate level supervisor can look at to prepare an evaluation. Perhaps limit it to the most recent last evaluation, and make sure that they don't get access to anything that would tend to show someone's protected status or their medical condition, whether they may have filed a workers' comp claim or something like that. You don't want to put them in a position where you're giving them access to information that someone might claim triggered a discriminatory response. So the nitty-gritty of performance evaluations in the context of collective bargaining can be complex, but in general, you do have a duty to bargain with a union representing your employees over the process, the forms, and the potential consequences of of an evaluation system or process. That's fairly broad, and there may be nuanced other issues in there that require bargaining. But in terms of setting standards and criteria, deciding who will do the evaluations, and of course, not necessarily in the context of performance evaluations, but deciding, as we're going to talk about in a little bit, when individuals should be disciplined, those are items that are considered managerial topics, and generally those issues can be reserved to the discretion of the public employer. But I think if you are in bargaining, you know, it may take a while to work this into a collective bargaining agreement, but I think that you'll have some success, especially if you emphasize it's an opportunity to identify and reward good performance as much as it is an opportunity to identify and respond to bad performance. Oftentimes our collective bargaining agreements don't differentiate based on contribution, skills, or performance. Everybody gets the same general raise, or they get the same step increase. Well, I think you might get some traction with your unions if you talk about how you might be able to identify better performers and at least thank them in an evaluation process.
And of course, for our school districts that are listening, you know, there are some specific legal requirements for APPR negotiations and what's required in those evaluations. Again, you'll see a link to that information in the note slides that you'll get after this.
Great. In terms of any civil service implications of performance evaluations, you have no statutory obligation to evaluate, but as we talked about, it's a good HR practice, it's a good employee engagement practice, and it can lay the foundation for the due process that's required to actually discipline and make some of these more difficult decisions that I'm going to now have Bethany talk about, the investigation and response to problematic behavior, make them easier for you and provide for a better outcome.
Oh, we're switching places. So investigations, and these can be difficult, sometimes not, but usually when you have a situation arise, you'll get a report or an allegation from someone who is complaining. Sometimes it's a harassment complaint, sometimes it's a complaint of misconduct by a coworker, or you've noticed misconduct by an employee. And what you want to do first is a pre-assessment, and you really want to decide how significant of an allegation this is, how significant of a situation. Do you need to take intermediary measures? If it's a harassment complaint especially, or a complaint involving the threat of safety to others, do you need to reassign the person who's the subject of the allegation? Do you need to remove them completely from the workplace and put them on an administrative leave? There is recent case law, at least in the school district context, that administrative leave paid is not disciplinary, so you do have the right to do that when you need to conduct an investigation. Do you need to preserve any evidence that might be out there related to the allegations? Does the person have a work-provided cell phone? Do they have a work-provided computer where there might be evidence? I would say take care if you're looking at electronic evidence on a computer or a cell phone, and make sure that you have someone that is knowledgeable about how to preserve that in the right way. I have been in situations or know of cases where they seem to have been lost because the metadata that's in a computer file, the last person who accessed it, who created it, those kinds of things were accidentally destroyed during the attempt to preserve the evidence. So you really want to make sure that if there is electronic evidence involved, that you contact someone that can preserve it well. Do you need to issue directives to the employee that's the subject of the investigation, or other employees that might be witnesses? that they're not to contact an alleged victim, that they're not to talk to each other, that they're not to interfere with the investigation, those kinds of things. So after you do that pre-assessment, is there further investigation that might be needed, and who should conduct that investigation? An example from a school district that I know that sets forth this idea easily is we had a situation where a building principal saw an employee grab a student by the neck down the stairs. All out of good fun and humor and teasing, but she didn't really need to do any more investigation for that because she saw it happen herself. But if there's lots of witnesses, if there's allegations that need to be looked into further, you'll want to decide how much more information that you need. And that's what I call whether a big I investigation is needed. What additional information is required to make an informed decision about an allegation of misconduct? Do you have a lot of witnesses that need to be interviewed? Do you have confidentiality issues that you need to address? Is there a potential allegation of bias with regards to a supervisor who might be conducting an investigation internally? All of those things are part of the decision-making process as to whether or not you want to conduct an investigation internally, or who internally you might want to have conduct an investigation, or whether you want to have outside help to do that. Do you want to call counsel? Do you want to have an investigator come in? For example, in a workers' compensation potential fraud situation, a lot of employers or workers' compensation insurance companies will send out private investigators to do surveillance of employees who they think might be defrauding the workers' comp system. So, anytime so just think about those types of issues anytime that you're considering whether to go further in an investigation. And we would always say, I think, Jim, that if you're not sure, go further into the investigation process, because finding out more information or finding out that there isn't any information, additional information out there, isn't going to hurt you. Being in a disciplinary hearing, either in an arbitration or Section 3020A or Section 75 for civil service, and finding out new information or that all of the information hadn't been gathered could be problematic for you and could affect your ability to get the discipline to stick. And remember, when you're doing an investigation, you or somebody from the outside, if you're speaking with a represented employee about something that may lead to their discipline, you have to offer them union representation. And if they say they don't want it, I would get that in writing, because after the fact, when they realize that they're going to be disciplined based upon some of the things that they said in that meeting, they're going to forget that they said that they didn't want their union rep to be there.
Yeah, Bethany, I like your use of the big I investigation. One of the questions that I'm often asked is, Jim, why don't you come out and do the investigation? Mm-hmm. There's certainly no problem with that, except that I have to explain to clients that if you take me from the role as counselor to the role of investigator, I may lose the protection of the attorney-client privilege because as investigator, I become much more a part of the process. Mm-hmm. So one of the things that I would include in the Big I investigation, I would tell all of you that the best use of your limited resources is to call your lawyer at that stage as you're deciding what additional investigation is needed and what form that should take, who should conduct it. One of the things that I think works well for Bethany and I is that a lot of times we'll actually help formulate questions, decide who needs to be interviewed, decide whether follow-up interviews are necessary, all with an eye toward potential litigation. And in this day and age, the possibility that some part of this might end up on YouTube or worse. You know, now we have to be constantly concerned about whether what appears to be an internal investigation will, you know, flare up on YouTube or Google or Facebook and become something much more than routine. So a plug, call your lawyers at the big I investigation decision and use them effectively, because I think that's the best time to get input.
Another couple of points to mention, and these are on the note slides. Remember, our tenured educational employees do not have to participate in investigations of their own misconduct. They have basically a right to be free of self-incrimination. Our civil service employees, unless it's in a contract, do not have that right. So we can require civil service employees to submit to a disciplinary interview under threat of an insubordination charge. We do want to be careful with that, because if we want them to submit in light of an insubordination charge, we have to agree that anything that they say during the interview won't be used against them in a criminal action. So if you are investigating an employee for criminal conduct, you may want to consider not requiring them to submit to an interview because you don't want to interfere with the potential criminal investigation after that. Another reason to call your lawyer. So at the end, once you've gotten that investigation completed and are trying to decide what to do next, you know, what do you want to do? You know, when we'll look at what we call the 7 tests of just cause in a moment, but the things that you need to look at, you look at the employee's prior work history, how good, you know, what's their attendance, do they have any prior discipline, how long have they worked for you, you know, all of those things will be factors in considering what level of discipline should be appropriate. You want to review the investigation report. And I reviewed a lot of these when I was at the Rochester City School District. And, you know, when I wasn't doing an investigation, which was very rarely, we had other people do that for us, there are often times when I would go through those reports and there were questions that I had where key facts didn't seem to have been answered. If that's the case and you take a look at that report and you see gaps, send it back to the investigator, whoever's doing that, to ask those questions again. You don't want to make a decision based upon missing information. Obviously consult your attorney. Depending on the circumstances, you could have an employee where there's a lot of potential litigation out there that you want to try to avoid, or at least protect yourself. It's not easy to avoid litigation. It's good, you know, it's easier to try to protect yourself if a complaint is filed. You'll want to meet with after you've gotten all your decision-making process started. You want to meet with the employee and the union. You want to make sure that you get the employee's position, or offer to get the employee's position in what has occurred. I have seen disciplinary arbitrations lost in situations where the arbitrator found that the employee engaged in the misconduct, but the employer didn't ask them if they did it, because that's one of our tests. So you really want to make sure, even if you have 100% certainty based upon all of the evidence, that you sit down with the employee and the union and you provide that employee an opportunity to explain what they did, or give them the opportunity to deny it if that's what they want to do. Then you determine the appropriate discipline. And we'll talk about how you decide what's appropriate when we go through the 7 tests. Once you've determined that, inform the employee of the union, and then you follow up with the supervisor. It's possible that you may have had a harassment complaint by another employee. You want to follow up with that employee as well and let them know that the investigation has been completed, that you've taken appropriate disciplinary action, and other steps that you may be taking to try to protect that employee against retaliation or further harassment as appropriate. You know, or indicate that you found that there was potentially no harassment. So when we get to the disciplinary stage, you know, you want to think about what the objectives of the discipline are. What was the cause of the problem that's leading to the discipline? Is it a performance problem that can be corrected through counseling and retraining, or is it a serious misconduct problem that needs to be addressed more harshly. If it's a misconduct problem, was there a rule that we didn't advertise or didn't promote effectively, so people weren't aware that that was something that they needed to know? We want to correct the problem, obviously, and that may mean terminating an employee that's a very bad actor, or it may be using this process to get them in line. Communicate with the employee. Again, this is another opportunity to communicate expectations. You want to make sure that you let them know what's necessary to meet those expectations and the consequences of failure. Again, through the progressive disciplinary process, having these very clear expectations identified and the consequences identified will help you in an arbitration or in a 3020A hearing if in the future you need to use that past discipline to support a termination later on. Finally, you also want to, in addition to correcting the problem with a particular employee, it sends a message to the coworkers if the problem is not corrected. Again, in most organizations, an employee's coworkers can see what's going on. If they see somebody get away with something that they consider to be bad behavior, they may repeat it. It could hurt their morale because they feel like they're doing good work and other people aren't, and they're not getting held accountable for that. It impacts your credibility as management if you don't address problems in the workplace, and also you want to be able to defend legal actions going on. We want to say that you can take non-disciplinary action. Counseling memo is not discipline, and in often cases it is a good opportunity to be able to correct minor problems in the workplace that don't merit disciplinary action. Other times we may use counseling memos to address more significant problems in situations where we can't discipline without a hearing, because the cost of a hearing is not is prohibitive based upon the level of discipline. And most of us aren't going to go to a disciplinary hearing unless we think that we're going to go for termination because of the cost and time involved with that. But you can issue counseling memos without having to go through a due process procedure, assuming that you don't have a collective bargaining agreement that would require you to do something with a counseling memo. Most that I've seen don't have that kind of requirement. So, do you want to do counseling or discipline? Is this a first offense, or is it a repeated offense or serious offense related to safety or other types of work rule violations? Is your goal to educate and problem solve, or is it more punitive, but do you still want to do some problem solving? Who does the counseling? Who does the discipline? If you're counseling, a supervisor generally can sit down with the employee and have that conversation without too many other, without other people present. And sometimes you're going to want to know who that employee is if they're problematic. But if you're disciplining, you definitely want to have another member of management in the room with you, and you'll have to have the union rep with you if you're going to issue discipline to an employee. You don't want the only people that are witnesses to what happens in the session, disciplinary session, to be the union representatives and the employee, because they're the ones that are going to testify about what happened in the room, and if their testimony disagrees with your supervisor's testimony, then you won't have anybody to corroborate. We do want to note that you should take care when issuing formal counseling, mainly to the extent that you don't want counseling to go so far as it appears to be discipline. Again, a written reprimand is discipline, and under Education Law 3028 or Section 75, you have to have a hearing before the discipline. So work with your attorney to develop language in a counseling memo that doesn't reach that level of a disciplinary action. Again, sometimes some collective bargaining agreements have provisions that would prohibit an employer from putting counseling memos in the official personnel file, because they're not, quote, disciplined. But you want to keep those outside in a separate file if that's the case, so that obviously you need them to record and document that prior counseling has occurred. But I think that, you know, counseling is really to identify, not necessarily to punish, but you can, I have seen them go a little bit too far and reach that disciplinary significance. Disciplinary processes for civil service employers who do not have an optional grievance and arbitration procedure for discipline. They would have Section 75 rights under the civil service law. Essentially, those rights would require that an employer have a disciplinary hearing prior to the implementation of any discipline. And that applies to competitive class employees who have completed their statutory probationary period, and labor and non-competitive class employees who have been employed with you for 5 years or more. It doesn't include non-competitive employees that may be in a managerial or managerial or confidential role with you who are exempt from collective bargaining. Also, many of us have collective bargaining agreements that do replace the statutory due process rights with grievance and arbitration procedures. What's nice about those, generally speaking, is that, except in cases of termination with the processes that I have seen in collective bargaining agreements, you can discipline and then you can you fight about it afterwards. So you can issue the discipline in a timely manner, correct the behavior immediately, and then the employee and the union can argue about whether the discipline was just and fair, but you don't have to wait for months for an arbitration to continue on, or for a hearing to go through before you can tell an employee 6 months ago you did something that you weren't supposed to do. Some termination provisions and contracts also allow you to terminate and then grieve as well, but you need to check your agreements to make sure. Again, educational employees, we have 3020A and Section 3020B now for termination of tenured employees based upon evaluation ratings. You cannot, for educational employees, waive the 3020A or 3020B rights with a contractual grievance process. You can have an alternate disciplinary process bargaining agreement, but it cannot be one that the employee has to be able to select the statutory process and have that option. One thing that I've found is effective if you do have an alternative process with educational employees is that frequently employees don't want their dirty laundry aired before a board of education, which has to approve any charges. So if you do have lesser discipline, like a reprimand or a short suspension, they may opt to go with the grievance and arbitration route so that they don't have to have the Board of Education know about the possibility that they might have gotten in trouble. You know, progressive discipline is generally a part of the due process framework. However, you want to make sure that you're not omitting in any collective bargaining agreement or any policy your ability to take immediate corrective action if there's a serious offense. Obviously, more progressive discipline seems fair in the sense that if there's legal action or a claim of discrimination, but you really want to make sure that you don't lose that opportunity if somebody does something very significant that you can terminate on a first offense. So here are our 7 tests of just cause. And we can look through these, and we'll talk about the more important ones. You know, these are a general rule in a lot of arbitration cases. However, I wouldn't look at these as a checklist that has to be met in every single circumstance in every single case. A lot of arbitrators will look at the more important ones that we'll speak of in a couple of seconds, but they don't. If some of these are missing, as long as it appears that the discipline was fair and reasonable, they will, you know, it'll generally stick. Just other than the one that I mentioned before, where the employee did it and got off on a penalty because we didn't ask him why he did it or give him a chance to deny it. So our more important parts of just cause: forewarning or foreknowledge. this is really, I think, the most important piece of a just cause termination. Does the employee know why they're being disciplined? Did they have notice that they would be disciplined for the conduct or performance issues before they were disciplined? And did they have an opportunity to correct if it's not a serious immediate violation? You want to know, so if you have work rules that you expect people to follow, you want them to be posted. You want them to be published widely. If you have an internal website or an external website where policies are published, that's a good start. When I was in human resources in the city school district, we posted on all of the bulletin boards and all of the buildings the most important policies. So we would say, make sure that we made people read them when they started, but we also posted every year when we checked the bulletin boards for mandatory notices. We would post something that said, here's where your harassment policy is, here's where the EEO policy is, here's where all of the important rules are that you need to follow. The other thing that you need to make sure that you're doing is that even if you have widely published and known rules, if you're not consistently following them or enforcing them, employees will be able to say that I didn't know that I was going to be disciplined because I had done this 6 times before and nobody said anything to me, or that person over there has done it 6 times before and nobody said anything to them. So I knew it was a rule, but I didn't know I was going to be punished for it. So you want to make sure that you're being consistent in the enforcement of your rules. And if a rule isn't important enough for you to consistently enforce it, then maybe we decide not to make it a rule anymore, because you want to make sure that what you're requiring of your employees is credible and respected. And again, any warnings, disciplinary notices, anything in employment evaluations will help with documenting the forewarning and knowledge that you need to establish. And this is the investigation of any misconduct is also very important. You want to make sure that your investigation is reasonably designed to elicit accurate information. Whenever you're talking to somebody that says that they know something about an incident, you really want to make sure that you ask them if they actually saw it or whether they're repeating to you something that somebody else told them, which happens especially in larger organizations, but even in smaller organizations where the rumor mill tends to get things out there pretty quickly. So you want to make sure that your witnesses have actually witnessed what they say that they're telling you. If you're not interviewing everyone, that's part of that was said to be a witness to an incident, you really want to make sure that you understand why that is. We recommend that you interview everyone, but there might be reasons why not. Are there credibility issues that you have to assess? So again, all of these things will go into the perceived fairness of your investigation. And again, fairness is going to be another big issue that an arbitrator or hearing officer is going to review. And the biggest part of the fairness is how have you treated other employees who have engaged in similar conduct. That does not mean in every instance that you have to give the same exact penalty for the same exact violation. But you really want to make sure that you have a basis for the difference. One person may have done something once, another person may have done it 6 times. One person may be a stellar employee who has phenomenal evaluations and always goes the extra mile, and there's a reason why you want to give that person a break. But if you're a phenomenal employee and you're not so phenomenal employee who's getting a harsher penalty, if their evaluations look the same, it's going to be hard to demonstrate that why you're treating those 2 people differently. If you're a larger organization, also think about what individuals in other locations or other departments, how they might have been treated with similar conduct. Frequently, different supervisors will treat employees differently. Some supervisors may be more lax in enforcement. That's not always going to be controlling, but you do really want to make sure that you're considering what's going on in your whole organization and not just in one small department. Again, the key is to be able to objectively explain why you made your penalty determination and why, if it's different, it might have been different for other employees. Reasonableness of a penalty, essentially that's the seriousness of the offense based, in light of the employee's record of service. Again, an arbitrator is going to be a lot friendlier to a long-term employee with a clean disciplinary record and good evaluations than they are going to be to a newer employee or an employee that has lots of counseling memos or discipline in their file, and who hasn't been able to correct their own behavior. So then when you're, and we hate to put this out there, but it is really a necessity when you're considering what discipline to issue. Even if you are 100% sure that an employee has engaged in misconduct, is there sufficient documentation and evidence to support termination if you're going to terminate? If I'm sure you've heard lawyers say this before, if it's not in writing, it didn't happen. You really want to make sure if you're saying that an employee has been counseled frequently for something, that those counselings are in writing. It provides evidence of your good faith effort to try to be fair to the employee. Because if you can terminate an employee, but if you get to the arbitration and you can't support it, that employee is going to come back, most likely with back pay, and it's going to look like a moral victory for that person. And again, that does hurt your ability to address that person's behavior in the future. An employee who may not be good for your organization will be coming back, and it's a morale issue for the rest of your organization. So if you feel like you don't have enough documentation or evidence to support a disciplinary action, work with your attorneys to take time to decide how else you might be able to address that employee's behavior short of termination. And I won't read off this because we're running low on time, but here's some things to think about with your disciplinary documents. You want to make sure that they're accurate. You want to make sure that they're factual, not opinion-based. There's nothing worse than seeing something that makes a supervisor or an investigator appear to be biased against the person who's being investigated. And you want to make sure that clearly that they evidence what you expect them to have evidenced.
Yeah, Bethany, let me follow up on that issue of documentation. No document will replace an informed and prepared witness. So I want to put the issue of documentation in context. You document to help yourself, because most likely you're going to be at the you're going to be at the top of the witness list when we get ready for a 3020A or a Section 75 or an arbitration. And so you really need to think about preparing the documentation to help you remember all the details and facts that were fresh in your mind when you investigated, when you evaluated, disciplinary action, and when you acted. So that has to really be the focus of the documentation. And if any of you have been on the witness stand and experienced that, you no doubt understand how important it is to have a piece of paper that you can use to refresh your recollection, because even the most experienced person sometimes forgets things, becomes a little flustered once they put you under oath and there's a number of people asking you questions. So that documentation really is there for your benefit so that you'll testify effectively when the time comes. We're going to try and wrap up quickly here with other issues to consider. Obviously, when you're doing these investigations, there are potential ramifications beyond simply the possibility of a civil service action under Section 75 or 3020A or arbitration. There may be external processes, Division of Human Rights complaints, EEOC complaints, other external processes that you may have to deal with. So all these things in terms of your preparation no doubt will help you defend those collateral actions as well. What we hope is that your efforts to prepare don't make those external actions more problematic. So obviously you have to be smart about how you go about discipline, what information you preserve, how you characterize, what language you use in characterizing behavior, and you need to look for that integrity across multiple disciplines, integrity across multiple performance evaluations, so that there's not even bias of which you're unaware sneaking into your process. The other thing that especially it's a little less common than in the private sector, but there are points in time when you may need to think about perhaps proposing a severance agreement in which you're essentially going to pay to have somebody to leave. Now obviously you have to be careful about the expenditure of public monies, but generally speaking, so long as there's a bargain for exchange and a release of claims, that's always permissible. I think that you know, some of you may have had the experience where it might be easier and more effective, more efficient to simply pay to sever someone than it is to pay your lawyers to battle this out in one of the many different processes. So that's something that should always be on your checklist as a possibility. You know, I think there's some nitty-gritty things you need to consider. You know, the last paycheck, calculating vacation and sick time, COBRA issues. The New York State labor law requires notice at the end of someone's employment about when their benefits end, when their last paycheck is going to occur, and you know, think about all those things in advance so that when you do meet with the employee, those things can go smoothly.
What I would add is that there are some, especially with the school district clients, but also with other public sector clients, the conduct the employee may have engaged in may create other legal obligations for you as an employer. You know, the thing that comes to mind most is our mandatory reporting requirements for certified school district employees, but that would also apply to social workers and others and other municipal organizations. You know, so you really want to make sure that if there are misconduct with regards to financial integrity, with regards to employees engaging in criminal behavior, that you check to see whether there are other obligations that you as the employer have related to reporting that conduct, so that you don't get in trouble because of something that somebody else did. And there was a question that came through about whether we recommend performance improvement plans after a poor performance review. Certainly, if you have the capacity to implement a performance improvement plan, that does, one, the hope is that it corrects the performance issues. But if it does not and you later have to discipline or terminate for performance reasons, the fact that you implemented a good faith performance improvement plan will help through the disciplinary hearing process to get the result of termination if you haven't been able to correct those problems.
Yeah, I agree with that, Bethany. I think you have to be judicious about when you do that, because I have seen that some employees just simply break down when you give them that performance improvement plan and it's 4 pages long and that type of thing. It sometimes prompts the very behavior that you're trying to eliminate.
Mm-hmm.
So I think if more informal measures don't work or the
Mm-hmm.
problems are very serious, then absolutely I think
Mm-hmm.
the performance improvement plan is important. We've run out of time, so I'm going to, some of the recommendations about the actual face-to-face meeting with employees, I'm going to kind of skip over, and if there's no further questions, Bethany and I would like to thank you for your time. We look forward to presenting again to you in our upcoming webinars. If things occur to you after the program that you failed to ask us about during the program, our contact information is in the materials. We're happy to answer follow-up questions that perhaps either we didn't get to or perhaps you failed to raise. We appreciate all your help. We look forward to working with you in the future. Thank you, Bethany, for the first of several presentations.
Thank you, Jim, and thank you, everyone.